Welcome to the Trial Bible, where we break down the secrets of courtroom victories with the best trial attorneys across the country. Each episode will sit down to explore their recent winning verdicts, the key pattern jury instruction charge that made the difference, and the tools they use to hit big. Let's go. Welcome back, folks, to the Trial Bible. You know, sometimes a case isn't about what happened, it's about what should never have happened in the first place. Today's episode is about a decision that set everything in motion, one that started fast and unraveled even faster. A pursuit, a split-second judgment call, and a chain of events that couldn't be taken back. But here's the thing. When you slow it all down in a courtroom, those split seconds start to look a lot more like a series of choices. And the question becomes, who's responsible when things go off the rails? This is a case where speed mattered, but strategy mattered even more. And joining me today are the trial lawyers who took that chaos, slowed it down, and turned it into a powerful verdict. Robert Chaiken, Paul Perkins, welcome to the show. Really excited to have you both on. And I want to jump right into it. So, gentlemen, tell me a little bit about who the client was before all of this happened.
All right, great. So, the client is a man named Anthony. He's actually about my age. So, he's 57, I'm 59. This accident happened 10 years ago, March 15th of 2016. Almost 10 years to the day from the day of our closing, actually. We closed on March 16th of 2026. So, before this, Anthony was a hardworking, gregarious, outgoing, loving person. We didn't even call actually his employers. It had been so long since he had been at work. 10 years. So we just had his employment records and all of his performance reviews from his job. And they were all glowing reviews, and not just the scores that he was getting, but the comments that his supervisor was making. He was talking about what a hardworking, dedicated worker he was, and how much he helped his coworkers and teammates at the job. He was a paver. He worked in paving, which is one of the reasons why he was on his way home from work on March 15th of 2016 at 4:40 in the morning, because, a lot of this road work is done in the middle of the night, to avoid the traffic. So he's coming home 4:40 that morning when he is struck out of nowhere by a fleeing vehicle that was being chased, we believe, recklessly and negligently by the Winter Garden Police Department.
This is a guy who had been living alone, independently, was involved in a lot of physical work, and his job was a super important, function in his life for him. He was really wrapped up in his identity. He was really good, believe it or not, at his job. He did everything for this company, and they loved him. I mean, literally, one of these records that we put on just happened to be gratuitous. It was done about a week before this accident, and it was just glowing, and it just talked about his enthusiasm for his job. So he was a great client to sell to the jury. There was no selling. I mean, he was a hardworking guy, and this obviously took, that component of his life away. He loved that job, and he was good at it. I mean, he made a lot of money doing it too.
So we have a hardworking, nice guy, respected by his peers. Age range was what, 50s?
So he was 57 at the time of the trial, so he would have been 47 at the time of this crash. And those records, they talked about not only how good he was at the job, but the fact that he used every single piece of equipment that they had with the company, and he was just well-rounded, just an unbelievable guy. That was his work. And then his sister and his mom talked about the type of person that he was with his friends, how he was extremely outgoing. He had lots of friends, he used to love to fish and play basketball and do all those things. And obviously, after this horrendous crash, he wasn't able to do any of those things.
So we have a likable guy. Now paint the scene for us in terms of what happens that morning. What county are we in? And how does it all kind of unfold?
All right, so we're probably going to bounce back and forth with this. I'll start. While Anthony McGowan is at work, 3 o'clock in the morning, about 3:42, a really serious forcible felony occurs where 4 to 6 black males break into the home of a fellow and they pistol whip him. They rob him of, I think, $30,000 worth of cash and some watches and some other things, some jewelry. And then they kidnap him and his female. I was going to say wife, but I don't know. And they drive off with him, with the victim, in the victim's car, which is a gray or blue BMW M6. He is dropped off in the middle of the street and runs to a 7-Eleven, uses a payphone, which I don't even know if those exist anymore, uses a payphone, calls 911. Okay. And then he gives a description of the 4 to 6 black males, that they were wearing all black, that they had on black masks, that they had assault rifles, pistols, that he was pistol whipped, and he describes the vehicle. He gives out the name of the vehicle, the description of the vehicle, and the tag number. He says the tag number ends in NZJ, but it is transcribed in the BOLO as NZG. Okay. When they run the NZG tag, it comes back to a white Mercedes SUV somewhere down in South Florida. Okay.
And they correct this. In other words, the BOLO and the police records, the dispatch channel corrects the misidentified earlier vehicle. So it says this comes back as a white Mercedes, and they're like, it's the wrong car because we're looking for a BMW sedan. So the records kind of get updated to reflect that.
Within about 5 minutes. Okay. Those records get read. Now, this officer by the name of Hudson positions himself on the road, which is a pretty major road through the middle of Central Florida. It goes all the way from the Gulf Coast of Florida across to the Atlantic coast of Florida. It's Highway 50, or in Orlando, it's called Colonial Drive for part of it. It's MLK Drive for part of it also. You know how that happens. So this is 50. 50 runs from straight through the state of Florida through Orlando. 60 runs straight through the state of Florida through Tampa over to Vero Beach. So it's a pretty major road. There's a mall on this road. There are lots of restaurants on this road. There are warehouses on this road. It's a very, very busy road, but it's 4:00 in the morning, right? So this officer, Hudson, who's 24 at the time or thereabouts, positions his vehicle under an overpass on this major road. Okay. About less than an hour, about 4:40. The guy was dropped off at 4:42. I think that call was at 4:46. And at 4:40, a vehicle comes past Cody Hudson, going a little bit over the speed limit, but consistent with how fast people drive that time of morning when there's little traffic. Okay, so speed limit's 45. He says that the guy was going about 60 or 62, but he didn't use a radar. That's just kind of he just sees him go by. There's no other cars, so it's not like he's comparing them to other cars. He just sees him go by and says, oh, he's going about 62. So he lights him up, meaning he turns on his headlights, not his siren and overhead lights, but his headlights.
And this car that just went by him is what type of car?
This car is a silver Mercedes SUV.
So the BOLO goes out for really a blue coupe BMW. There's a minor mistake with the tag that brings a white Mercedes van, but then it's quickly corrected through the BOLO. BOLO, by the way, do we know what the acronym stands for?
Yes, be on the lookout.
And so these officers know that there is a high crime that just happened recently. There is a lookout for a type of vehicle. And this Officer Hudson starts to initiate a chase with this silver vehicle.
Mercedes, correct. So I don't know how to do this chronologically, but he initiates this chase. Now, in his deposition.
First, just tell us what happened.
Okay, first I'll tell you what happened. All right.
Perkins already has forgotten half the case. Now, basically what happens is he lights this car up with his headlights. This car, the Mercedes, does a quick U-turn, and right away, this car starts to, he says, looks like it's being evasive. He thinks the people in the car, he claims he saw some people in there being furtive. Although he's looking for 4 to 6 black males, he really only saw maybe 2 people. This chase starts, and it is quickly a developing chase. This chase lasts about 3.1 miles is the distance before this collision occurs, and they cover it in about 1:30 seconds, which will become a, kind of a case cracker fact a little bit later on as we're talking about this. But at the same time this chase is going eastbound on Colonial Drive, Anthony's coming home from work, minding his own business on a green light, going through the intersection to get to his house, and he gets plowed into by the fleeing vehicle, the Mercedes, at a very high rate of speed. The officer then comes up a couple seconds later, maybe catches up to him, gets out of his vehicle to go to see what's happening with Anthony's car and the Mercedes. And the officer's car gets struck by another motorist that had been coming through the intersection at the same time. So there are actually two collisions at the same intersection, almost simultaneous.
It's important to note also, this chase goes through 6 traffic light intersections, all right? 6. Some of the information is that he's going through red lights. Some of the information is that the lights aren't red, they're green, but by the time Hudson can get to the light, it turns red. So it cycles through green, yellow, and red. And so that is why, because Hudson is following all the rules, he keeps slowing down through these intersections. And so the guy keeps getting further and further away from him. That's part of the testimony. So 6 intersections, very high rate of speed.
And so your client's vehicle gets hit by the fleeing vehicle. Is that correct?
Correct.
Just
Yes.
one impact.
Massive.
One impact.
Massive. The damage to the
Massive
vehicle was they had to cut him out of the vehicle with the jaws of life. Our client barely doesn't really remember the accident or the impact at all. He's basically taken, by ambulance to the hospital, and he's got, a major amount of injuries. But I mean, this was a high speed collision.
Broken femur, he's got a bilateral pneumothorax. He's got his diaphragm is severed to such an extent that his internal organs are forced up into his chest cavity. His spleen is ruptured, requiring a splenectomy. He's got a brain injury. He's got just all types of very, very serious injuries. As a result of the splenectomy, he gets thrombocytosis, which results in him having a stroke 4 days. He's in the hospital for 11 days, goes home, has a stroke 4 days later. The doctors causally relate the stroke to the splenectomy, which is causally related to the crash. And he, has a lot of physical limitations and never works again. Got mental and cognitive deficits to such an extent that he can never work as well. So very, very serious injuries.
Any dash cam footage or videos from the area, from the intersections, from the chase itself?
So great question. The police department, the Winter Garden Police Department, made use of dash cams and body cam videos. And one of the kind of issues at the trial is that the pursuing officer, Hudson, his dash cam and body cam video didn't work. The only information, it's highly suspicious or coincidental, depending on how you want to view it. But from that perspective, the only data or evidence in the case that had any memorialization of what was occurring in real time, he did call in this chase on dispatch, but it is very choppy, and really he provided no information. That's one of the problems with the case is he didn't really provide the information that he was supposed to provide so that a supervisor could have made a decision maybe to call off the chase. So he didn't call off any speeds, didn't call off what kind of traffic was out there, didn't call off all the intersections that he'd gone through. And importantly, he never called for the actual identification of the vehicle. He didn't say, hey, I'm chasing a Mercedes. He just said, I'm chasing a vehicle I think was in this kidnapping. So that his supervisor really never had any information, nor did anyone else on the dispatch. Now, what happened is to your point, which is a very good question, is there was some dash cam video and body cam footage that came into evidence, and it came in through other officers who had responded to the scene right after the accident. And so while the defense was trying to argue, it wasn't very crowded out there on the roadway, it wasn't very dark, conditions were suitable for this kind of a high-speed chase, we actually had video of one of the officers responding at the same level on the same roadway, and he passed like 25 cars on the way to the scene. And so the jurors got to see, although they didn't see the actual footage from Hudson's vehicle, they got some lay of the land of what it actually looked like that night in terms of how dark it was. This cop that was coming to the scene was going pretty fast, so they had an appreciation for just how fast it looked. And as he was already starting to pass, other vehicles, they understood there was more traffic that had been represented out there. And then one of the things that happened in this dash cam and body cam footage from the other officer is that at the scene, another officer comes up, sees Officer Hudson. There was a witness who saw somebody fleeing from the vehicle. They start talking about it. And the other officer goes, "Hey, you've got the wrong car. This is not the car that was in the kidnapping. We were supposed to be looking for a BMW. This is a Mercedes. You got the wrong car." And so that was like that was the first time the jury kind of heard that in trial. That was one of these aha moments because everyone else knew kind of in the case who was supposed to be, being chased. And this guy, kind of the officer, pursuing officer, had it wrong.
One of the key things was they all knew that it was a BMW and there had been a correction on that Bolo. And we kept asking every single witness when the officer came up and said, "Hey, this is the wrong car. This is a Mercedes. We're chasing a BMW M6." I would ask all their witnesses, "How did he know that?" And Hudson didn't know that, and none of them had an answer.
So I want to talk about the theory that you guys took when you started the trial, because it wasn't just a chase happened and this is the result of a chase. You framed it around two big ideas. Can you share with us what those were?
The big ideas were really the requirements of the case. There's two you got to prove in these cases. One, either that there wasn't a reasonable suspicion or reasonable belief that the vehicle that you initiated the chase with was involved in the actual forcible felony. That's one. Or the chase itself was so reckless that it was essentially a total disregard for the safety of persons and property in the area.
There's two components. One is whether or not it's proper to initiate the chase at all, whether or not there's reasonable basis, objective, reasonable evidence that you've got the right vehicle, that there's an immediate threat of harm to the public, that the vehicle that you're looking at has done something more than just a minor traffic offense. I mean, there's about 4 or 5 factors in a policy that governs whether or not you can even pursue a chase. But even if you have the right vehicle and you're righteous in your pursuit to initiate, then you get the governing components to the methodology of the chase itself, that it has to be safe, that it has to be conducted at reasonable speeds, that there can't be a lot of traffic or intersections or pedestrians. In other words, even if you have the right to initiate a chase, then you still have to conduct that chase. And it's a constant balancing test that's set out in almost these policies really exist in police departments across the country, which is there's a constant balancing of is the need for apprehension outweighed by the potential danger to the public, which can even be the vehicle. But in this case, obviously in Anthony's case, that's exactly who the policy is designed to protect, because this was clear in this case. There was no way and no evidence, nobody ever indicated that Anthony did anything wrong, should have foreseen this, should have noticed that there was a fleeing vehicle heading his way, could have avoided this or something like that. I mean, he came off as, and he was completely innocent, victim here. Not one thing, could they say.
But the key is on the chase, you can't just prove it wasn't safe. You have to prove that it was reckless. So it's actually a higher standard and was more difficult. So we really were putting a lot of effort in initially, putting a lot of effort in trying to prove that he didn't have enough facts to support the initial chase itself. And here's some of the key facts. So he was supposed to be looking for 4 to 6 black males in the BMW. He ends up saying that he saw 2 people in the Mercedes that passed by, and they were dark-skinned or light-skinned blacks, right? So turns out there was really only one person in that car because when you look at the body cam of the same officer whose dash cam we used in the case, when he talked to the witness says after he hit this car, he ran that way behind the Lowe's and he took off. Never mentions anybody else, doesn't say the other 2 ran this way or the other one ran that way, nothing. There was only one person in that car. There was also other evidence that didn't come up in the trial of who the person was in that car. And it was actually a Vietnamese male who was in that car. And that car had actually been reported stolen by the owner of it. But none of that came before the jury because we had a motion in limine out that the only evidence that the jury should consider is what Officer Hudson actually knew at the time he initiated and continued the pursuit. And so there was a lot of other evidence out there that didn't come in.
So let me ask this question. I mean, it wasn't the officer's car that hit your client's vehicle. So was there a third-party defendant here, the Vietnamese gentleman who actually did not pull over for this officer and went through the traffic light and ended up being the sole person that came into contact with Anthony's car?
That was a huge argument at trial. Obviously, they don't get a question. Obviously, causation became a big defense theme, which is our officer didn't do anything wrong. It's the fleeing felon that did it all wrong here, and that's who you should blame, and that's the culprit here. But they don't get in this case in Florida, they don't get a. They call that a Fabre defense. They don't get a question on the negligence of the fleeing vehicle. And in fact, we spent a lot of time with the experts and with their witnesses focusing on the fact that these kinds of collisions are foreseeable, that fleeing vehicles, can in fact and will in fact get into these kinds of accidents if these pursuits aren't conducted safely and carefully. And that's why there's all these policies that are designed in the first place to protect against this from happening.
It's kind of like a negligent security case. That's an intentional act of fleeing. And so there's no question of negligence on the verdict form. An intentional act is not on the verdict form.
They just argued causation.
They did, in fact, point to the empty chair and said, look, our officer did the best that he could. And really, who's to blame here is this other fleeing felon.
Correct.
Absolutely.
I want to take you guys into, we say it voir dire. I know down in Florida, voir dire, everyone says a little bit differently. What do they say in Texas, Rob?
Voir dire.
There you go. You got to get that Southern charm in. Okay. So let's go into voir dire. What are you trying to get out at jury selection with this room? How do you go about the questions and the answers that you're getting, and how do you flip it to people that you want?
So that's actually not our objective. The key for us is hater hunting. Okay. You know how trial lawyers are. We all talk to one another. And what the prevailing stuff down here in Florida is the thought that you're going to actually ingratiate yourself with the jury and find people that are for you can happen, but it's not your primary objective. Your primary objective is to find the people who are haters in these types of cases and get them off the jury in any way that you can. As it relates to the police question, as Rob was saying, the question we ask is something like, listen, if you hear two people tell a story and the stories are different, and then you find out that one is a police officer, even to the slightest degree, more likely to believe the police officer than the other person, simply based on the fact that you found out they're a police officer. And we got answers for both. Some said, yes, I would. My uncle's a cop, blah, 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 blah. My mentor was a cop. We have all kinds of stuff like that. But then some said, no, I think cops, say whatever we think they need to say. And we think just the opposite. So, that question, it got the people that we want off, but it also got the people that they want off. That doesn't bother me. As long as the people that we hate are off, we can work with the other folks.
That was a pretty hot button issue. So, for every person who said, yeah, I trust police officers, I believe police officers, I was brought up to trust police officers, there was someone else who would say, I think they're incentivized to lie. Public news lately suggests that if you don't have video, you don't know what these officers are really up to. They're capable of all kinds of impropriety. Literally, they said they're incentivized even to lie. Things like that. So it almost neutralized the panel almost, because both sides then were striking these folks for cause. So literally, if there was people were one way or the other on police enforcement, they almost canceled out.
Was there any other topic or question that you ask in jury selection that is going to tie in to really your closing statement, where you repeat back to them, you remember I asked you and you guys said yes? Is there any kind of question like that you can think of that you really liked and you thought worked for this particular case?
Well, because we had an officer, we had his deposition testimony, we had his trial testimony, we had his written reports, and there were inconsistencies in all of it. That question that we just talked about was one that I featured when I did the close, because we came at, particularly in rebuttal, we had a very, very brief rebuttal, and I was able to say, listen, I hate to say this, but you simply can't trust a word that Officer Hudson says. It was different in his deposition testimony, different in his report, and different in when he came in here. The way that the case and all of the evidence came in, it was almost perfectly in line with what that guy who didn't even make it onto the jury said, which is they're incentivized to lie. They say what they think they need to say to make it. I mean, all of that was exactly what happened in this case when you looked at his report and heard his testimony. And so I think that was actually one of the main ones.
And did the jury find out why there was no dash
The
cam?
only other question in Vordire was his end opening is we told him it was going to be, we were going to be asking for a large number, multiple millions. We didn't give him an actual number. We qualified the panel on the case was going to be about economic damages and then a significant non-economic, component. They were all, inquired of about their abilities and did they believe in, damages for loss of enjoyment of life and things like that. You can't go to them in Florida and said, do you think a million's fair? You can't really do that. Can't qualify them that way. But they were qualified on the notion of this was going to be, did you have a problem if there was huge money that was going to be? And then in opening, we did the same thing. We didn't tell them a number. We gave them the economic numbers, which came out to about 3.5, 4 million in economics. But we told them that at the end of the trial, based on this evidence, we'd be asking for multiple millions. And so at closing, it all lined up. Those two questions on liability and on damages, got reinforced and then they lined up.
Are there any particular questions? I ask this of almost everyone. When you're trying to explain to the jury that the number that we're looking for is this arbitrary award for pain and suffering, how do you guys go about lining that up in jury selection with respect to that's what your job is going to be? It's going to be about pain and suffering, loss of enjoyment of life.
Some people find it very easy to award damages like lost wages and medical bills, but struggle with awarding money for pain, suffering, discomfort, and disfigurement and things like that. Do you even hesitate for a minute? Anybody, raise your hand if you hesitate in awarding damages for those types of injuries. And I can tell you, 10 years ago, a lot of hands used to go up saying, yeah, I can't give money for that. I can't do that. That's different. Everybody has pain, that kind of stuff. Within the last 3 or 4 years, I mean, I've asked that question and had not a single hand go up. I don't know if it's COVID. I don't know what happened, but there was a shift. And I think Rob would agree with this. Well, I've been asking a question like that since I've been practicing 35 years. I've been asking that my whole career. And the answer, the response from juror panels, I mean, of every political ilk, I'm finding very little hesitancy to award money for those types of damages.
And we tie it to the fact that they're going to get specific questions for these items. Then when we open, when I open, I show them the verdict form again, okay, in the opening and go right to the actual wording verbatim of the questions for liability and for damages. 'Cause a lot of them walk in there thinking they just get to decide who wins and loses. They don't realize they actually get, line itemized questions. And so they are tuned up for the questions and the vocabulary, before the case even really gets started.
I touch on it when I'm talking about burden of proof, actually, in another way. So my burden of proof spiel is, you've heard greater, preponderance of the evidence, greater weight of the evidence. You've heard all those things, it's 50% plus a feather and that kind of stuff. And I say, look, does anybody have a problem? Anybody football fans, they raise their hand, everybody knows football, and it says, sometimes you see a game and it's 55-10, and that's a win, right? But sometimes you see a game and it's back and forth, and it ends up and it's 7-6. Anybody have a problem with the fact that 7-6 is just as much of a W as 55-10? And everybody says, yeah, they understand that, right? Then I ask later when I'm talking about damages. Now you've heard we're going to ask you for millions and millions of dollars in this case. Anybody here have a problem? We talked about burden of proof a few minutes ago. Anybody think that when you're asking for millions and millions of dollars, that you need the score to be more like that 55-10 than that 7-6? Anybody think they need more evidence to award damages, a lot of damages, than they do? And then a lot of times they just go, no, they get it. A W is a W. 7 out of 6, 7-6 is just as much of a win as 55-10. It works. So we kind of touch on it numerous times in voir dire to make sure they understand we're talking about a lot of money here in this case.
I want to jump into opening statements. You mentioned some of it, Rob, with respect to you at least tell them at the outset that we're going to be talking about millions of dollars here. A strategy that I have kind of shifted towards is mentioning money in opening, but I also give them a pretty good range of what I know I'm going to be asking for. Have you ever considered that? What are your thoughts on that, giving a range as opposed to just saying millions?
So, we've talked about that a lot. And I used to not even really bring up the money at all, really, other than to say, they'll be asked to award it at the end. I personally, the way that I do it is if I know the economics, I literally give them to them right in opening. I lay out the economic, what they're going to hear. They're going to hear from a life care planner, forensic economist. These are the numbers. These are what they're going to look like. I even fill them in sometimes, during opening. Then I go to the non economic components and I just tell them that this is the kind of case because the injuries are so significant that we're going to ask you for millions and millions. But I want you to hear all the evidence first before I ask you what kind of money. So we ask them for the money in the end. On closing, what we did is as we asked them for a specific number and we tied it to the life expectancy table.
We'll get to the closing. Hold on. Don't jump the gun on me.
To your point, I don't ever ask them for a specific dollar number or even a range on opening because I don't think you have to do that. And I don't want to back myself into a number or even a range that maybe for some reason later on the evidence just it didn't go in well. Maybe the guy, maybe the client ends up looking like he's fine on the stand and I'm afraid of boxing myself in. So I don't do it. I know a lot of people do.
I haven't decided usually at opening what I'm going to ask for. I'm not kidding. I usually don't know because I can't tell. I get a very good feel for what a jury is thinking, I think, in trial. A lot of people. So in Florida, we have questions. The jury can ask questions of the witnesses as they come through. And the way it works, I don't know if you're familiar with this.
I am not, and I'm blown away about what you're about to say.
Wait till you hear this.
It is the closest thing to a scoreboard in a trial I've ever seen in my life. Okay. I've been doing it. I think it came about in Florida maybe 15 years ago, right? And so maybe a little longer. That gives me a very good idea of what the jury's thinking and what I can ask for and that sort of thing. So I really am not in a position in opening. And when me and Rob do cases, I very infrequently do opening. He usually does opening and I close. That's just the way we've been doing it. And when I do openings, I don't even know what I'm going to ask for at the end. So I don't touch on that.
Okay. Fair enough. Were there any other points in opening that you strategically decided to leave out? Was there a fact or two that you knew was going to be a wow factor when they heard it from an actual witness or during trial or on cross that you decided, let me not lay this one out in my opening?
Wait, let me just preface this. I'm going to let Rob tell this, but I'm going to tell you my belief. This is what won the case.
Okay.
So the defense acknowledged that this was a high-speed chase. In their paperwork, though, they had kind of figured it out. They kept saying it was around 90 miles an hour. Speeds got up to maybe 100 miles an hour. But that was all that they were willing to kind of cop to. In opening, we told the jury, yeah, this is...
Wait. They also said that in every intersection, in the 6 intersections, that he slowed down to 60. That the guy he was chasing was being really safe and slowed down to 60 as he went through all 6 intersections. That's what he said.
Their defense was, high rate of speed, around 100 miles an hour, and very short in duration, 1 minute and 30 seconds. So we did the math. For whatever reason in this case, when experts were deposed, when witnesses were deposed, nobody ever did a time distance mathematical calculation. We knew the number, but we didn't tell the jury the number in opening or in voir dire or otherwise. We waited until the first, I think I called the lieutenant first, was the first witness. And I said, you told us you thought this was a high rate of speed, but do you know how fast this was really going? Do you really know what speeds were at work here? No. What are you talking about? I just know it was around 100 miles an hour. Well, the math came out to an average speed of 124 miles an hour for the time distance. To cover 3 miles in 1 minute and 30 seconds, you can just Google this. And so it was like an aha moment because then the jurors were like, it wasn't just sort of fast. It was 125 miles an hour average, which meant if these guys slowed down to 60, they probably got up to 150 at times. And we think that's why it got to reckless. We think that the officers were all like, well, it still could have maybe been okay, or maybe that wasn't reckless anyways. But the jurors were all keyed on the number. So that was the one strategic number or fact that we held back until we put it on the first witness.
So you got to understand, Gennady, one of the things that they felt was one of their key factors was that this duration was so short that there wasn't time to cut it off. And so they thought that fact was for them, the whole case. In fact,
That it was a minute 30-second chase.
well, he said it was a minute 29 seconds. He was trying to shorten it even, right? And then when they figured out the speed after we asked a couple of witnesses, and he put on the supervisor first because we were going to put on Hudson first, but Hudson didn't show up the first day, right? And he said he had an emergency. He's now working with another agency. He said he had an emergency and couldn't come the first day. So we had to put the supervisor on first. So it came out first with her and not with Hudson, but it worked out fine. That was the key. They thought that was their best fact, but it ended up going right up their noses. And then they started trying to back off of it. Well, we're not really sure it was a minute 30. It could have been more with the tie. It could have been as much as 2 minutes. They tried to, but it was too late because he got up in opening and said it was a minute 29 seconds. He said it definitively. That was the defense.
I just want to emphasize here because this is where great trial lawyers start to separate themselves. You put on their officers before you put on your own expert. Is that correct?
Yes.
Correct.
Tell me the strategy of why you decided to do that.
Frankly, if we put our expert on first, we were concerned that they would use that to prepare their witnesses.
And they just try to and come up with even newer, more, ridiculous excuses. But this is we trapped them down in the courtroom on the speeds, on the duration, on the videos. So by the time we put our expert on, it was all out there. So it wasn't just him reviewing the reports and reviewing the case and from his deposition. Then we took our expert and we just more or less said, this is the evidence at trial. This is where we're at. And then confirm the opinions. And it was very hard for them to wiggle. I would recommend in any one of these cases to take the officers first every time, for sure.
And remember that 3.1 miles, 90 seconds, that would have come out in our experts' testimony. So that was all part of the holding that back until we had them friggin' locked down. And once they were locked down, our expert was able to, just throw them out of the
Did you have any extremely effective exhibits that you thought really also additionally tilted the scale here?
Yeah, the dash cam and the body cam of the officer that came to the scene right after the crash was a very, very significant exhibit because of what was revealed by the officer when he got there and how many cars were actually on the road at the time of the crash.
What I thought was the most effective exhibit was an opening. We showed it. We put these two vehicles side by side and showed what I know it almost sounds overly simplistic. And you're like, why would you waste time doing that? But we literally showed an opening, a picture of a BMW sedan blue and a SUV Mercedes, white or silver. There it is. Okay. And what was weird is we showed him that. And then when Hudson testified, the actual officer, Paul had him and showed him this and said, you agree these are different, right? And the officer said, no. I think they're similar. They look alike. And it was one of these things. No, literally. he said no.
He did. And Gennady, one of the witnesses in the question, one of the jurors, that was one of their questions. How can you say those two look alike? That was one of the questions from the jury.
I'm curious about this because we definitely don't have it in New York. You mentioned it, Paul, but tell me a little bit more out of my own curiosity. When you say the jurors can ask additional questions, like what kinds of questions were you getting in this case after which witness?
Okay, so let me tell you that you tested my memory now. I'm 59. I don't know if I told you that, Jenna, but the way it works is this. After a witness, any witness, expert, lay witness, anything, after a witness testifies, the judge says, anybody have any questions? The jurors have a notepad that is given to them by the court where they can take notes and ask questions. So they start ripping off pages and asking written questions. The questions then go to the judge. The judge calls up the lawyers and this judge, and this is the first time I've seen this, she had a form where you fill out on the question, you fill out whether you object to it or whether you think it's fine.
Sometimes they ask questions that aren't appropriate, like, is there insurance in the case or whatever?
Right.
So the court's not going to ask that question.
an example, like with Hudson, one of the questions was, how can you say those two vehicles look similar when they don't? Um, if speeds of 135 miles per hour, how can you say that's not reckless? I mean, there's questions like that. Rob, can you think of any of the other questions for some of
Oh,
the other
there's
witnesses?
several others, which is what did anyone else other than the one missing tag number to the white Mercedes? Did the white Mercedes ever come up in anyone else's? Did the victims ever say there was a white Mercedes involved? Did anyone else ever say they saw a white Mercedes involved anywhere in the records, or whatever? I mean, these jurors were paying attention. So here's the thing about these questions. Here's the rest of the story. So the judge decides what questions to submit. The judge actually had questions of her own, starting to ask questions. And then they let the lawyers go back and play cleanup on the questions that the jurors had. So it's almost like you're starting over a little bit. It's like a free for all a little bit. But the nature of the questions suggested that the points that we were driving home were the point. Like Paul said, it's kind of like a scoreboard. I mean,
And Gennady, that's when you're talking about asking for money, that's the sort of thing that gives me an idea of how our evidence is going in and how aggressive I can be on the ask. Right. So if we were getting a bunch of questions that were negative to our case, and I don't remember any really, if we got any questions that were negative to our case, I believe it would affect my confidence level of what I would ask for at the end. That's what I mean when I say scoreboard. It's almost like in a football game, whether, the score depends on whether you go for two or not. It's like
Yeah,
one of those.
understood. What did the jury end up finding with respect to liability here?
that
All
was
right.
reckless.
They found recklessness, which for some reason was the first question on our verdict form. So they did not answer the question about whether or not he had a reasonable suspicion at first because they didn't have to. They were the way the verdict form read, they were allowed to skip because they only needed to find one. It was an or, right? You answer yes to question one, you can skip the question, skip down to the question about causation.
There's a series of questions that are geared towards whether or not you get through the sovereign immunity hurdle. And one of those questions is, was the pursuit conducted in a reckless manner that demonstrated a reckless disregard for public safety and that kind of thing? If they answer yes to that, or that there was no reasonable suspicion, or a couple other questions, then they move on to a question that says, do you find that there was negligence? So they still have to find that there was negligence that was a producing cause or approximate cause of the injuries. And so then they answered yes to that. If they found that there was reckless conduct in the question above to get through the immunity hurdle, then they're going to answer yes to negligence because it was a lower standard. They could have said, well, it was reckless in one sense, but he was still reasonable. I don't know. But once they answer those two questions, then you're moving on to damages.
So in Gennady, I'm going to go back to something we talked about earlier. One of the questions that was part of the sovereign immunity questions, which was their burden to prove, was that he was actually trained on the policy. So there was a policy called General Order 60, and that was the policy on chases. And they had to prove that he was trained. So as I went through the verdict form with the jurors, they proved that he was trained twice on it, right? A fact that was in their favor, right? And I said, yes, you got to answer, yes, he was trained on this. And we know he was trained on this because he knew the policy so well. He knew exactly what facts to flub and to fib on to fix this mess, right? He knew that he had to write in here that they were only going 100 and slowing down at 60. He knew that he had to say that there were two males in the car, not one, because two is a lot closer to four than one. He knew he had to say that the Mercedes looked similar to the BMW. And, I put all of those things in there. And so we were able to use that fact to echo back to what was said during voir dire when the guy said, hey, they say what they need to say. I'm convinced the more I do this, every fact is a double-edged sword. You can use almost every fact against the other side and vice versa, frankly. So you just got to be kind of creative in how you do it.
Interesting. And you saved all those facts for your closing on when you piled it all on in terms of what he knew and what he did.
Well, no, it wasn't really saved. I mean, that came out in all the testimony. It certainly came out in the direct of our expert and in the cross of their expert in our questioning of the supervisor and of Cody. But we were able to add it all up, at the end and just kind of succinctly state it. And we had the report that he wrote 24 hours after this had all of those misstatements in it and all of that stuff he was doing just to tweak it enough to make it in his mind, a safe pursuit.
And so their expert on liability, his ultimate opinion was that the officer did nothing wrong?
Yeah, his ultimate opinion was that the reasonable suspicion is a relatively low bar, and that overall, with all these facts and circumstances, he still thought that he thought it was reasonable that at night that maybe he would confuse the two vehicles. He actually messed up the standard. He thought that there was maybe some threat of immediate harm, even though he couldn't identify the immediate harm. I mean, his ultimate opinions were this was a reasonably initiated pursuit, and that the conduct was okay. He was willing to say, yeah, they're just, these officers are familiar with that area. They know about traffic. Whatever the traffic was out there, it couldn't have been too heavy. He was being careful with these lights. I mean, he wouldn't budge, not an inch. Here's the thing about their expert. He didn't do the math either. So
Right.
by the time he got on the stand, he couldn't deviate from the average speed of 124 miles an hour. What he then tried to say was simply is, well, you don't know when in the time frame that they may have reached those speeds. And so that would be a factor I would need to know to have an ultimate opinion on if this was reckless speed or not. And I was basically, well, what difference does it make? 125 miles an hour average in a minute and a half means they were flying. And he was like, well, not necessarily. And I wasn't going to argue with him. I was like, fine. Okay. I mean, the jurors were all
No,
like,
let me tell you, it's also Gennady. One of the key things in that testimony was and we got to go back a little bit. Hudson, in his deposition, said he was never aware that NZG tag number was associated with a white Mercedes. He didn't know that. He only knew it was a wrong tag, but he never knew anything about a white Mercedes. So that was his deposition testimony. He changed that testimony at trial. During the cross of their expert, Rob asked him, did you read the testimony of Hudson when he said he didn't even know there was a white Mercedes involved? And he said, no, I didn't read his deposition. I glanced at it after I came up with my opinions, but I didn't read his deposition. So he didn't do the math. He said, I wouldn't do the math. That's not something that I would consider. He didn't even read the deposition testimony of the main witness in the case.
so we didn't depose the expert. That was the other thing. We didn't depose their liability expert. We just took them live at trial. There was a snafu. When we went to go do it, they were resistant. We were towards the end of the discovery deadline. I actually, in a lot of these cases, don't bother taking the deposition of these experts. If you can
That
force,
was like an 18-page report with
you
all
know,
of his.
why give them a dry run, or trial run of what it might even look like anyhow? I mean, you've been doing this long enough. You probably are the same way. You don't really need to take, as long as you have something to.
In New York,
key
we
on.
don't depose experts at all. No one
I
does.
was going to say, in some places they don't even do it,
Yeah,
right?
we don't do it here.
Yeah.
They do have to give reports, though, right?
Yes,
in New York.
Yes. All right. So let's move to damages. You already brought one really beautiful piece of information out, which is you brought a performance review from your client's job, which was really intended to humanize this guy, to make him really likable, and to show who he was as a person, prior to putting on the damages here. Anything else that you found really effective testimony with respect to humanizing your
Oh
client?
my God. His mom and sister. So you got to remember, after that stroke, this guy who was completely independent, making upwards of $68,000 a year, working hard, he became essentially a ward of his mom, who was 79 at the time of the trial, 69 at the time of this crash, and his sister, who's 61 at the time of the trial. They became his caregivers. I mean, cooking for him, driving him everywhere, everything. So we talked about that. They both testified. They were amazing. And then I said in closing, I said, listen, and you heard from his mom, you heard from his sister, you heard what a great person he was, you heard how many friends he had. And listen, I would love to have brought some friends in here that could tell you what he was like 10 years before. But it's been 10 years. His friends are gone. It's hard to maintain your friendships when you are not the person you used to be. And I said, his friends know Anthony. They don't know this guy. And I pointed at him. And I mean, the jurors, one of them looked over and she had a tear in her eye. That was very, very, the mom was unbelievable. I mean, I had to walk her up. The judge asked me to walk her up to the stand, and I did. And the jury knew, one, that these were wonderful people, that Anthony was a wonderful guy, but they also knew this lady is not going to be able to take care of this man for much longer. Probably not tomorrow, right? And then his sister's old, and she had a condition where she can no longer drive. So he's got a cousin that they didn't testify, but we testified about it. As a cousin and a brother that drive him to the store when he needs to go to the store, and that kind of just all the inconvenience and all of the difficulty in him living his life now compared to what he was like before. We believe that was very good damages testimony, but also in opening, Rob said, this is an important case. Spent a lot of time talking about it, so much so that I was like gigging him for it after. I was like, hey, man, you spend too much time on that crap. But he was
Everybody's a
saying
critic,
how
by the way. Everyone's a critic.
he was everybody's great. He talked about how important the case was. So I got up in closing. I said, listen, my co-counsel got up here and told you this was an important case, and here's why. And then I just went through the discharge summary of all of the conditions that Anthony got as a result of this, right? And then, he had lost vision in his right eye. Just all of it. It was like, I don't know, 15 things on there, right? And then I talked about diagnosis. And then I talked about I went through the life care planner's assessment of him and all of the cognitive deficits he was having, and the difficulty doing things and activities of daily living and so forth. Went through that. And I said, so this is an important case. And I was able that was at the beginning of closing. But then I spent so much time, Gennady, on the facts of the chase and the facts of the pursuit itself and of the initiation of the chase that I only had 10 minutes left to have to go through all those questions for the damages. And I had to wrap up damages in about 7 minutes to give me 2 or 3 minutes for rebuttal. And so, you got to remember, in this case, during the middle of it, we're getting all this stuff. I know that the jury is with us. We hear in the middle of our case that there's another big case at trial. So I'm kind of geeked up. So I go through and I do a brief statement of, so in Florida, in the close on the verdict form, they list various elements of pain and suffering damages, right? Non-economic damages. They talk about pain. They talk about suffering. It talks about loss of the capacity for the enjoyment of life. It talks about aggravation. It talks about inconvenience. It talks about disfigurement. And his hands were all jacked up. And I was able to talk about that a handshake is the way that we make a new acquaintance. And now he has to be self-conscious about his hands. Each and every one of those elements, I said, these apply to each and every one of the things of the injuries that he had. He now walks with a permanent limp. The pain, I said, pain is what you experience. I said, suffering is the memory of pain and the anticipation of pain. And then we go through that. And I did that. And I said, look, and it's been 10 years almost to the day. Yesterday, and this was Monday, I said, Sunday was March 15th, 26th. That's 10 years after this accident. And for those 10 years, it's $1 million a year in pain and suffering. His life expectancy is 23.7 years. And it's not going to get any better. In fact, it's going to get worse. But we believe a reasonable amount for you to pay for pain and suffering in the future is $23.7 million.
So we tied the ask $1 million for each year in the past, 10 years in the past, and then $1 million a year on the life expectancy table. That's how we calibrated it. That was the ask. That was the scale, if you will.
It's really powerful when family members come in and testify on someone's behalf. I think that's the difference between a jury really understanding that your client is a human versus someone that just filed the lawsuit. I just had a case I was telling you about, Rob, that I hit for 7 figures on. The most powerful day of the case was my client's son came in, 23 years old, to testify about what his dad used to be like prior to this incident. It was the most, I'm not lying here, I've been doing this for not as long as you guys, but I got 10 plus years of doing trials. The most emotional day I've ever experienced, where I have a 23-year-old son crying. I have his father crying, watching him. I have the jurors crying. I have a judge tearing up. That kind of, I cannot stress enough to every attorney listening. You have to find that one person in your client's life that understands what this incident did to that person. And that person has to come into court. So it could really open up eyes and feelings on how it is that this accident changed that person's life.
His mother and sister were incredible witnesses because they clearly were not coached or prepared I mean, it was obvious that they were
They
in a
clearly loved him. They loved him to death.
loved them. They just told a story. They were fish out of water in the courtroom, though. I mean, it was very authentic. I mean, more so than sometimes. You can over prepare witnesses or script something ahead of time. But I mean, both his mother and sister were incredible witnesses. The other thing that I think really helped was the independent, objective, the performance review, the appraisal that
Yeah.
was done just a week before. Because it was, if you can get, first off, you can get anyone at work to say anything nice about you. That's unusual anyhow. It was completely gratuitous. It was in a form. It looked like an official performance review of this guy. It was very detailed. It was a separate corroborating piece of evidence that this was not only a good guy, but a really hard worker, and his job really mattered to him. We thought about, should we go try to find a boss or something like that? And we're like, nah, we'll just use the report. It's even better. You know what I mean?
And here's why, it's way better because what we do at work, particularly guys, we don't tell people at work how we're feeling, right? So the testimony wouldn't have been nearly as good and as poignant as those forms were. And I used to think that that was exactly who we were looking for, someone unconnected to the family, because those people don't have a dog in the fight. They wouldn't come in here and lie and all that. But I think you're right. It's a family member because that's who really sees you, and can really talk about not only how it's affected you, but how it's affected them and their life with you. And it comes out even if they don't have any sort of a filial consortium claim or anything. The jury gets it, and the relationship is closer. So the evidence, I believe, the testimony is more
Yeah.
emotional and better.
I mean, people at work don't know what you're going through at home or how you live at home. I mean, there's no question. His mother was very articulate in terms of talking about, that he was different, that his friends stopped coming around, that his demeanor has changed, his memory was different. He can't cook for himself at all. It just flowed very naturally. It didn't look like it was set up in any way at all. She just really told this guy's story.
Yeah, and one thing I asked them, and you can't ask a coworker or a boss this, I asked all the lay witnesses. I asked the mom, I asked him, and I asked her, "What do you worry about for his future?" You know, and they were both able to talk about. And I asked him, "What do you? Your mom's 79. What do you worry about when your mom and your sister aren't able to take care
I
of you?" And
love
he
that question.
he said he'd give up. He literally said he'd
Yeah.
give up.
So I don't know. I might just have to give up.
No,
I mean,
and
Really powerful question. Is that something you prep him on, or it's just something that flows naturally?
no, flows naturally. I do it every time on a witness, like a family member before and after witness. I always ask what they worry about.
Did the defense throw out a number at closing?
No, closest thing he said was, "There is no way to quantify the effect this has had on Anthony." That's what he said.
Did you get a chance to talk to the jury after?
We talked to the alternates. So in Florida, they are told, you are free to talk to the lawyers if you'd like, but you do not have to. And so we can't approach them. They have to essentially approach us. But we did talk to the alternates, and that was while the jury was deliberating. They made us pretty confident as well.
So if there's one thing trial lawyers are listening to that they want to take something away from this type of case, police pursuit, high injuries, what's the big lesson here?
sometimes less is more. In other words, on the front end of this, we kept back that whole speed calculation thing was crucial. I mean, you had this, all this workup, all this legal maneuvering, and that kind of thing. And that fact never really came up. So sometimes, get away from your documents maybe. And, you're so focused on what people said or didn't say, and just step back and think about what's really happening. Because we didn't really even develop this theory about this excessive speed and the average speed calculation till really late in the case. And I mean, I always believe sometimes less is more. You can overkill a case by doing too much or trying to over lawyer it. That was my takeaway, was just because I think that one simple fact probably moved the needle as much as anything in the whole case. And it really was no big deal. It was no genius move.
You got to understand, my emphasis on this case from the beginning was on that initial pursuit, because one, the standard is lower, right? I don't have to prove recklessness. Two, I really believed in my heart of hearts that was the main problem. They should never have even started chasing this guy, right? And that's what I thought the case was about. And then we got together and realized they were going really freaking fast here, right? And then it turns out that's what the jury based it on. They didn't even get to the question I thought was the most pertinent. I think they would have, if they had to answer, they would have answered in our favor. I would say, don't get too married to your theory of the case, like I did, right? Because there may be something else out there that's just or even more important.
That's excellent. Well said. Folks, what you heard today is what happens when great trial lawyers don't chase the case. They control it. They took something the defense wanted to frame as quick, justified, unavoidable, and showed the jury that it was none of those things. They turned motion into moments, moments into decisions, and decisions into accountability. That's the craft of what we do. Because winning cases like this isn't about being the loudest voice in the room. It's about knowing when to press the gas, knowing when to hit the brakes, and when to let the evidence speak for itself. And if there's one takeaway from this episode, it's this. The best trial lawyers don't just tell a story, they control the speed at which the jury understands it. If you want more of that, real cases, real strategy, and the exact moves that lead to real verdicts, make sure you come back next time on the Trial Bible. Rob and Paul, it's an absolute pleasure to speak to you both. I appreciate you both so much for taking time out of your day to speak with us, to give us some of these gems that you've given us today. It's really an honor and a privilege.
Thanks. You, man. Thanks for having us.
Enjoyed it.
That's a wrap for this episode of The Trial Bible. We hope you've gained some valuable insights. Don't forget to subscribe, rate, and review so you never miss an episode packed with winning tactics and expert advice. Thanks for tuning in.